Hi, this is Dr. Perry Carpenter. I'd like to thank you for taking the time to join me on this week's program. In this new program, I want to talk to you about probably the single most critical, the single most important, the single most pivotal, the single most crucial issue that we face as qualified medical evaluators. Now, I know that may seem to you to be a strong statement, but let me ask you, when you think about all the issues that we deal with, issues ranging from temporary disability to issues related to permanent impairment to issues related to your apportionment determination, of all the issues that we deal with as qualified medical evaluators, what would you say is the sine qua non, the supreme issue that we deal with? What would it be? Well, I'm sure you'll agree with me that the single most important issue around which all cases revolve has to deal with industrial causation. That is what we refer to as AOE, COE, because without industrial causation and without some accurate opinion from us as qualified medical evaluators, either for industrial causation or against industrial causation, we have no case. So all of the cases that we see begin with a determination for or against industrial causation. And many times the sole reason that we're brought in as qualified medical evaluators is to provide an opinion as to whether or not an industrial injury occurred or not. And that's what I want to talk to you about in this new program. It seems that doctors struggle with the causation determination. And number one, that's a problem because number one, it's not necessary. There's an exact formula that I want to share with you today for arriving at your opinion for or against industrial causation. I want to share with you a systematized formula that you can use in each and every case to help you arrive at an opinion that will likely be true and accurate a very high percentage of the time. So it's not necessary to struggle, and I want to share with you a formula today that you can implement that will eliminate your struggle. And it's also a problem that doctors struggle with their causation determination because an incorrect determination on causation has devastating consequences for the case and for the examinee. And let me give you an example. If you erroneously opine against an industrial injury in the case of a bona fide injury, you irreparably harm the examinee or the applicant, perhaps irreversibly, denying that person necessary and important benefits for medical care and for income protection during a period of time that they recover from such an injury. Well, on the other hand, if you erroneously opine for an industrial injury in the case where no industrial injury has actually occurred, imagine the amount of time, treatment, money, resources, testing procedures that are all being provided unnecessarily. And imagine the amount of money and effort and human capital that's wasted on an erroneous decision for an industrial injury. And I can't tell you how many times in my own experience I've opined for industrial injuries that later turned out to be a wrong decision. Well, in today's modern era, it seems that these problems still plague us, and doctors are constantly faced with the difficult determination as to how to decide to opine either for or against industrial injury. And I want to share with you in this program some insider secrets as to how the best qualified medical evaluators go through a systematic thought process, a systematic logical sequence, a systematic algorithm that you can use to help you arrive at a conclusion that will certainly qualify as substantial medical evidence at least, but more importantly will be accurate 90, 95, and even 99% of the time if you just follow the simple steps and understand a few basic concepts that we'll get to in today's program. So let me set the stage for this program. I want to begin with you by going over several of the labor codes that deal with the causation determination. And it's important that we understand the philosophy behind these labor codes, because many doctors do not. And sometimes when I speak with doctors on the phone and I reference these labor codes, doctors have no working knowledge, no tip of the tongue knowledge of these labor codes. And these labor codes are critical to have a fluent understanding of as you go through your causation analysis. So we'll begin by talking about some of the important labor codes. Then I want to refer to the new 2016 Physician's Guide. And by the way, I have a download link for you with this program to bring you an electronic copy of the new 2016 Physician's Guide. So we'll review what the 2016 Physician's Guide has to say about causation, and we'll jump back and forth between the labor codes and the Physician's Guide to establish parallels and similarities between these two references. And then I want to share with you a step-by-step flow sheet as to how you would make an apportionment determination in a difficult case, and how you could simplify the whole process to arrive at a bottom line decision that's substantial, that's supportable, that you feel comfortable with, that you feel confident with, and that you are prepared to support by way of supplemental report or by way of deposition should your opinion or conclusion on causation be challenged. And I've been challenged many times on my causation determination, and I want to tell you honestly, it's many times, many more times than I care to admit, that I've been embarrassed about the substantiability, or I should say the lack of substantiability, of my causation determination. I don't want you to ever have to go through the anguish that I went through in being embarrassed in not being able to support your causation determination. So I want to give you a series of steps and a series of checks and check balances that you can use that will help you arrive at a confidence level that indeed your causation determination will hold water. It'll stand up. It's supportable. It's substantial, and that you're prepared to defend it. Doesn't mean it's going to be correct in every single case, but it means that you're prepared and you're confident to stand behind it, because you have many reasons and many facts that support your opinion and conclusion. And many doctors, when I ask them, so you're opining either for or against an industrial injury, correct? Let's say in this example, the doctor is opining for industrial injury. So you're opining for an industrial injury, is that correct? The doctor will tell me, yes, that's correct. And I'll ask the doctor, well, tell me, what is your support for that conclusion? Or on what basis do you make that conclusion? And many doctors will simply say, well, I believe the examinee. Or I believed him. That the examinee's testimony about the injury was true, was accurate, and was sufficient to opine for an industrial injury. And I'm here to share with you that that is not sufficient facts and sufficient reasons upon which to provide an opinion for an industrial injury. And I just used that as an example, and we could go the other way as well with an opinion against an industrial injury. So I want to strengthen your causation determination to the point where you're prepared to defend that determination by way of supplemental report or by way of deposition, and that you're confident, comfortable, ready, willing, and able to do that. Okay? And then finally, we'll illustrate the principles of the labor codes, of the Physician's Guide, of our algorithm and flow sheet, and we'll illustrate those principles in 2 to 3 cases that were difficult causation determinations. And I'll show you how these specific case examples benefited by the philosophy that I want to share with you here today. So I have a couple of references that I'm going to be referring to today. Today we're going to go over a couple of labor codes, And so I'll take a quick break to go ahead and retrieve labor codes 4060 and labor codes 5402. I've also provided these for you as part of your download materials for today's program. So please go ahead and assemble those materials, and I'll be back with you here in just a few moments as we begin our brand new program on the ironclad determination associated with your AOE and COE industrial causation determination. Okay, I'm back with you now and have my references, which include labor codes 5402 and labor code 4060. And then I also have a couple things to share with you related to the Qme Panel Process. And I have with me here today Qme Forms 105 and Qme Forms 106. So let's go back to the beginning now. Let's go back to a point in time where you get a phone call. Your phone rings, and it turns out to be an appointment for a qualified medical evaluation. And because you have great experience in doing these types of evaluations, you wonder to yourself, I wonder what type of evaluation I'm involved in. And there's a finite number of possibilities of the type of evaluations that we're involved in. Now, the two most common scenarios of evaluations that we're involved in are those cases that involve examinees who have gone through treatment associated with an industrial injury. They're now permanent and stationary, and we're called in to provide an opinion as to their level of permanent impairment and any apportionment of the permanent impairment, if any. So perhaps the primary treating physician has done a permanent and stationary report, and the claims administrator considers that report to be insufficient or inaccurate or whatever, and a dispute is declared, and we're called in to resolve the dispute related to permanent impairment, related to apportionment, related to the need for future medical care, etc. So that's one class of evaluation that we get. The other main class or type of evaluation that we get is the compensability exam. Compensability exam, where we're called in to provide an opinion as to whether or not there's a case here, whether or not there's a claim here. In other words, we have an applicant, we have an examinee who's claiming an industrial injury, and the employer or the claims administrator is not convinced that there is an industrial injury, and they're calling us in to provide a medical determination as to whether or not an industrial injury exists. This is the compensability exam. So when your phone rings, you're thinking to yourself, what type of exam am I doing? Well, in this program, I want to talk to you about the compensability exam, because it's the compensability exam where industrial causation, meaning AOE and COE, is unclear. It's unestablished. It's uncertain. We're being called in to provide such an opinion. Now, in the other scenario where we're called in to provide an opinion on permanent impairment and or apportionment, industrial causation has already been decided. In other words, this examinee has already had his claim accepted. He's already gone through medical treatment. He's already had temporary disability, perhaps. And now the claim is coming to a conclusion, and we're called in to conclude the case. Okay, so we're not talking about that type of case. In that type of case, industrial causation has already been established. We're talking about the other scenario, not the end of the case scenario. We're now talking about the beginning of the case scenario, where industrial causation is either in dispute or sometimes flat out denied by the claims administrator. So those are the two main classifications of examinations that we will be getting when the phone rings. Now, most doctors are familiar with the end of the case scenario, and they're familiar with their role in the end of the case scenario. I find that doctors are not as familiar and are not as fluent and are not as comfortable with their role in the beginning of the case scenario, where industrial causation is not so clear. And that's the purpose of this program, is to make you a black belt Ginsu master at the causation determination in those cases where industrial causation has not yet been clearly established. Okay? Now, it's important that you understand some things about the Qme panel process before we move forward. When you get a call for a Qme appointment, many steps have already taken place. Now, one of the steps that have already taken place that results in your phone ringing is that somewhere, some party, whether it be the examinee, claims administrator, an applicant attorney, a defense attorney, some party has requested your evaluation to resolve the dispute. Well, in requesting the evaluation, the parties have to fill out either Qmu Form 105 or Qme Form 106. And I want to go over these very briefly with you to show you how these forms establish the type of examination that we're going to be involved in. Okay? So beginning with Qme Form 105, this is the form that we use when we're requesting an evaluation for an unrepresented employee. Unrepresented employee. So one or the other party, either the employee or the claims administrator, fills out this form. And in the very center of the form, you'll see that I have it highlighted here in yellow. It asks the requester to declare the reason for the panel, for the Qme panel. And it says check one of the following 4 reasons. And reason number 1 is to determine if the injury is work-related. To determine if the injury is work-related. This is called the compensability exam, where we're called in to make a determination, either yes, the injury is work-related, or no, the injury is not work-related. Now, in the case of this type of an exam, the compensability exam, this form requires that the claims administrator attach a notice to the form, attach a notice that the claim was denied, or a copy of the claims administrator's request for an evaluation. So this is the type of evaluation, and this is the box that the party will check in those cases where the claim has been denied, where one of the parties is requesting an evaluation to determine the compensability of the injury. Okay? So as we're going to see, this type of evaluation is covered under Labor Code 4060. It's the compensability exam. It's the exam that comes at the beginning of the case, not at the end of the case, at the beginning of the case, to determine if we even have a case. Okay? Now, Qme Form 106, this form is used for injuries before 1105. For injuries after 1105, this form is completed online. This form is used for injuries before 1105, but both the paper form and the online form require the party requesting the evaluation to declare the reason that the Qme panel is being requested. And that's right here. I have my finger next to it. And the very first option I have here highlighted in yellow is the Labor Code 4060 compensability exam. Okay? There's a couple of other types of exams, and we've already talked about this one here, the permanent disability dispute, and the other is the non-medical treatment dispute. Okay? There's really a finite and very limited number of reasons that we're called in as qualified medical evaluators. One of the main disputes that arises is a dispute over the compensability of the injury. And that's an evaluation that's covered. under Labor Code 4060. Okay? So I want you to start thinking when your phone rings for an appointment. Start thinking to yourself and asking yourself, what type of exam am I going to be involved with? Is it a compensability exam? Is it a permanent impairment dispute exam? Now, one of the clues that will strongly tell you what type of exam that you're involved in has to do with the date of injury. If the date of injury is significantly removed from the date of your evaluation, it's a good chance that that's a claim that's already been accepted, the examinee has already gone through treatment, and they're now coming to conclude their case with you for an opinion on the permanent impairment and the apportionment and the need for future medical care. If the date of injury is relatively proximate to the date of your evaluation, say somewhere within 90 to 150 days from the date of injury, this examinee is requesting an evaluation with you, there's a good chance that that could be because the claim was denied and you're being called in to determine the compensability of the claimed injury. Okay? So before we talk about Labor Code 4060, let me back up even before that and give you a little preface about some philosophy that takes place even before the compensability dispute arises. And this has to do with Labor Code 5402. So let me set the scene for you and establish our scenario. We have an employee who is claiming an industrial injury. He comes to Human Resources or he comes to the supervisor and he reports an injury and he says, I want to fill out a claim form. A DWC Form 1, an employee's claim of occupational injury form. And in Human Resources, the manager gives the examinee, or in this case the employee, the form, and the employee describes his injury from lifting boxes in the warehouse, and he dropped the box on his foot, and because there was pain he took some medicine, but now his stomach is upset from the medicine. And on the claim form, he lists injury to the lower back, the left foot from dropping the box, and the stomach from effects of medication side effects. Okay? I'm just making this up. But on the claim form, we have lower back, left foot, and gastric distress. Okay? Well, Labor Code 5402 tells us how to proceed once the employer has a claim form. And let me read it to you. This is Labor Code 5402, sections B and C. It says that if liability for this injury, for injury to the lower back, the foot, and the stomach, is not rejected within 90 days after the date the claim form is filed, the injury shall be presumed compensable under this division. So the employer is not sure if an injury took place or not. Well, the employer has 90 days to decide whether to accept or reject this claim as an injury. They have some time to do some investigation. They have some time to think about it. They have some time to do some interviews. They have 90 days. But if they haven't rejected it after 90 days, it's presumed to be an accepted claim. Okay? But they do have some time. Now, that time comes at a cost, and the cost is described in the very next section, Section C of Labor Code 5402. It says, within 1 working day after an employee files a claim form, okay? So employee files a claim form today, that means by tomorrow, within 1 working day, the employer shall authorize the provision of all treatment for the lower back, treatment for the foot, treatment for the gastric distress, all treatment for the alleged injury, and shall continue to provide the treatment until the date that liability for the claim is accepted or rejected. And until the date the claim is accepted or rejected, liability for medical treatment shall be limited to $10,000. And this is known as the $10,000 rule. So we have a separate pot of money under Labor Code 5402C. We have separate $10,000. Now, if the claim becomes accepted, medical treatment then starts to be provided under the separate pot of money for the claim. So $10,000 play money to use during the period of time where the employer is trying to decide whether to accept or reject the claim, $10,000. But if the claim is accepted, then this money is no longer used and treatment and benefits come out of the claim. Okay? So the $10,000 is to be used to provide medical treatment for all injuries until the time that the claim is either accepted or rejected. Okay? So let me ask you, if the injury was clear-cut, if the injury was witnessed, if the injury was bona fide, if the injury was actual, if there was no red flags and no dispute over the injury, the claims administrator is going to accept the injury, correct? And the draw and the impact and the burden on the $10,000 is either none or minimal, because all treatment would be provided under the claim because the claim has been accepted. In clear-cut cases, the claims administrator accepts the claim and begins to provide benefits under the claim, correct? What kind of cases are not so clear-cut? What kind of cases involve a dispute? What kind of cases would the claims administrator not accept? They would not accept the cases that have red flags associated with them, correct? They're going to immediately accept the clear-cut bona fide witness cases. They're going to delay and ponder and investigate those cases that have associated red flags. But Labor Code 5402C says that they can do that. They can take their time. They can take up to 90 days. But during that 90 days, until they either accept it or reject it, in other words, until they make a determination, they're on the hook for medical care for all conditions up to $10,000. Do you follow? Okay? Now, put yourself in the position of the claims administrator. If you have a claim that is not so clear-cut, that has red flags, that was unwitnessed perhaps, that involved a delay in reporting, that involved different stories as to how the injury occurred. In other words, the claim has red flags with it. What are you going to do as a claims administrator? Well, in order to stop the bleeding from the $10,000, you simply reject the claim. You quickly and in writing reject the claim. That stops the bleeding from the $10,000 and gives the claims administrator up to 90 days to investigate the claim and to decide whether to accept or reject the claim. Now, what is one of the ways that the claims administrator can use to investigate the claim? And in cases where the claim is denied, what is one of the ways that the employee, the applicant, the examinee, what are one of the ways that they can prove that an industrial injury occurred? Both parties have the availability of us to do their investigating and to do their proving for them. That's why we're called in these compensability exams, because the claims administrator considers our medical determination as part of their investigation, and the injured worker considers our medical determination as to the presence or absence of an industrial injury as part of their evidence to prove their claim. The QME is pivotal for both parties at this stage of a claim that's not so clear-cut, of a claim that's been delayed, denied, or even outright rejected. Does this make sense to you? Does this help clarify why you're getting so many calls for claims that have been denied? It's because the claims administrator has found some concern regarding the veracity of the claim. There's some red flags associated with the claim. The claims administrator is not going to deny a clear-cut case, a case that involves a bona fide witnessed incident of injury that was reported immediately, that was witnessed by the owner of the company. They don't deny those cases. They don't delay those cases. In those cases, industrial causation is clear. It's already established. We're called in to make a determination on industrial causation in cases where it's not clear. There's red flags, there's concerns, and we're called in to resolve those concerns. And we're called in because the claims administrator has done a brilliant financial move. They've stopped the bleeding from the pool of money that they're obligated to use while they take their time to decide and investigate the claim. It's called the 4060 compensability exam, and you're going to be getting, and you have been getting, a lot of these, and we're going to talk exactly how to handle these and what your role as a qualified medical evaluator is in this unique subset of cases. Okay, so let's just review Labor Code 4060 and establish our philosophy for this program. So Labor Code 4060 is known as the compensability exam. Here, the requester of the QME panel specifically has to check the box that says 4060 compensability exam. So let me read directly from the Labor Code for you. It says, this section shall apply to disputes over the compensability of any injury. This section shall not apply where injury to any part or parts of the body is accepted as compensable by the employer. So in those cases where the examinee has gone through medical treatment, has been declared to be permanent and stationary, and we're called in to resolve a dispute over permanent impairment, this section doesn't apply because that case has already been accepted as compensable. This is to be used for those cases where compensability is in dispute. It says, if a medical evaluation is required to determine compensability at any time after the filing of the claim form, and the employee is represented by an attorney, then we're referred to the procedure in Labor Code 4062.2. Okay, that's for represented. For unrepresented, it says if a medical evaluation is required to determine compensability and the employee is not represented by an attorney, the employer shall provide the employee with notice either that the employer requests a comprehensive medical evaluation to determine compensability, or that the employer has not accepted liability and the employee may request a comprehensive medical evaluation to determine compensability. Now, both of these sections are fascinating as relates to represented injured workers and unrepresented workers. They both begin by saying if a medical evaluation is required to determine compensability. Now, in cases that involve disputes over compensability, most of those disputes over compensability do not require a medical determination. So here's the number of disputed cases. Only a small subset of the disputed and denied cases require a medical determination. See, that's what we do as qualified medical evaluators. We provide the medical determination. What's an example of a case that is disputed or denied and does not require a medical evaluation? Well, There are many, but let me just give you an example. Let's say an employee comes to the employer and says, yesterday I suffered an injury to my back while I was lifting in the warehouse. Okay? The employer looks at the work schedule and sees that the employee was not scheduled to work yesterday. Okay? That is simply a factual and an administrative denial. It doesn't require a medical determination because the facts are administratively non-compensable. The employee says, I hurt myself yesterday. It's a total fabrication because he didn't even work yesterday. That type of situation does not require a medical determination. And there's a few other scenarios that I'll share with you when we get into the Physician's Guide and another labor code, the Conditions of Compensation Liability Labor Code 3600. But a few cases require a medical determination to determine compensability. And in our next segment, we're going to talk about what is the qualified medical evaluator's role in providing the medical determination. How does the medical determination translate into an opinion either for industrial injury or against industrial injury? So I look forward to being with you in our very next session where we resolve these difficult issues and I show you a step-by-step sequence now that you know the $10,000 rule, and now that you know about the compensability exam, and now that you realize that these determinations come at the beginning of the claim, we now set about a series of steps and sequences of events and logical progressions through an algorithm to come up with a determination either for or against an industrial injury, and the determination has to be considered to be substantial medical evidence. And we'll get into that into our very next session.